Hey guys, what's up? It's Debbie. We are back with day 3 of the Amber Alert murder trial, or the Kidnap Kids murder trial, whatever you want to call it. New Hampshire v. Dustin Duren shot the mother of his children and then took off with the kids. They'd been together off and on for a long time, but they were never married, so I don't think we know yet if he had legal custody. If we do, I missed it. But he said that it was self-defense, or not self-defense, but defense of his kids, because she was holding the 4-year-old daughter and wouldn't let her go. So basically, she was being kidnapped by the mom. I don't know. Crazy story. Anyway, state's supposed to rest today. Hopefully, we'll hear from him, his side of the story, but I don't know. It's a crazy story, as all of these things are. Okay, let's see what Judy has. A celebration of Caitlyn's life took place in June 2024 in Minnesota. Her obituary described her as small and mighty, quiet, fierce, and brave. She was survived by parents. Oh no, she had a twin. She was survived by parents, siblings, including her twin, Taylor. Oh, that always makes me so sad when a twin dies, because they have such a special connection. Her loved ones would like her to be remembered by her spirit, the spirit as a whimsical wanderer, along for the ride, up for the adventure. Her spirit is joy and lives on in her 2 beautiful girls. Oh, that is so sad. Marty, it didn't work for me either. On my laptop, I had to click on it too. So, I don't know. Yeah, and now the kids don't have a dad either. So, people don't think. I asked Travis that question once when about his ex-wife, because she not only cheated on him, she tried to move the man into their house with them. And I remember asking him, why didn't he kill her? And he said, I thought about it, but then the girls wouldn't have a mom or a dad, because then he would go to prison for killing her. So, and that was smart. These people don't think. They're not only taking away one parent, they're taking away both parents, because then they're going to get caught and go to jail. They just don't think about the consequences of their actions before they do it. It's so pointless. From the back, this guy looks like nope. See, this is what I mean about Judge Darrow being on time. I am so far. You guys see how far I am into this stream? Nothing. Spike, mommy's busy. I will give you a bite in a minute. I think they're standing for the judge because the judge isn't there yet.
anybody has had any exposure, even if inadvertent, relative to any media coverage,
Oh,
you could
and the
please
jury.
raise your hand and we will address it.
Can we have better mics today, please?
Observers raise their hands. Thank you very much. Appreciate your compliance with my instructions. Okay, Attorney Spicer.
Thank you. The state calls Dr. Mitchell Weinberg.
Bo or Fa? That must be a restaurant thing.
Dr. Weinberg, could you raise your hand?
Yes, sir.
Do you swear that the testimony you're about to give will be true under the pain and penalty of perjury?
Yes.
Thank you. Please have a seat. Good morning. Could you please introduce yourself to the jury and spell your last name?
Sure. My name is Mitchell Weinberg. Last name is spelled Weinberg.
Dr. Weinberg, where do you work?
I work at the New Hampshire Office of the Chief Medical Examiner, which is based in Concord.
What is
Oh, medical examiner. Cool.
I am the Deputy Chief Medical Examiner.
what are the duties and responsibilities of the Deputy Chief Medical Examiner?
My primary job duties relate to conducting and overseeing medical legal death investigations, including the performance of postmortem examinations such as autopsies.
Before we get to what an autopsy is, doctor, do you have any education, training, and experience relative to your position as the Deputy Chief Medical Examiner?
Yes, I do. So after attending university and earning a bachelor's degree,
Yes.
I went to medical school, graduating from medical school in 2008. I then completed an anatomic pathology residency at Ohio State University, completing that part of my training in 2011. And then the last stage was a forensic pathology fellowship conducted in Baltimore, Maryland, at the Maryland Office of the Chief Medical Examiner, and completing that in 2012. So at that point, I'd completed all of my schooling and training, and I was ready to enter the workforce as a staff forensic pathologist. And I did so, taking a job in Alberta, Canada, in 2012, holding that position until 2020, at which time I relocated to New Hampshire to take this position at the New Hampshire OCME.
Thank you, doctor. You mentioned forensic pathology. I'll ask you first, what is pathology?
Pathology is an area of medicine focused on the study of human disease. It's a very broad field of medicine. Pathologists are often called the doctor's doctor because generally pathologists do not interact with patients directly, at least not very much. Rather, we provide diagnostic information to other physicians so that they can provide treatment to their patients.
So that is pathology. Could you tell us what forensic pathology is?
Sure. Forensic pathology is a branch of anatomic pathology that is focused on the application of principles of pathology and medicine as they can apply to areas of the law and also to some extent to areas of public health.
Does forensic pathology, or is forensic pathology concerned at all with determining cause of death?
Yes, that's a core function of any forensic pathologist's job. It's overseeing medical legal death investigations, and one of the primary reasons is to determine why an individual has died, i.e. the cause and manner of death.
So when conducting one of these medical legal investigations to determine the cause of death, does that include a review of
It's all gone, Spike.
diseases, but also trauma or injuries?
Yes.
I'm sorry, it's all gone.
What is an autopsy?
An autopsy is a surgical-like medical procedure involving an examination of a deceased individual. It involves an external examination as well as subsequent internal
It's
examinations
all
to
gone.
document the presence or absence of
Quit
various
grunting at me.
disease processes as well as the presence or absence of various injuries or traumatic findings.
Dr. Weinberg, what is the general procedure that you follow when you conduct an autopsy?
The general procedure is that a body comes into the autopsy suite. I start with documentation of the body as received into our facility. I then undress the body, clean the body so that I am getting a good look at the cleaned, naked external surfaces of the body for documenting those various findings. Then the procedure continues to an internal examination, which is examination basically from the head down to the pelvis in a standard forensic autopsy. So that, again, to be clear, means opening the chest, abdomen, examining the organs internally, again, for the presence or absence of natural disease processes, the presence of or absence of injuries, and also examining the neck and head contents for those same reasons.
Dr. Weinberg, does your general process for conducting an autopsy include a screening in the way of toxicology?
Yes, not at that same exact moment of time. So during the course of the autopsy on the day of examination, those specimens are collected, and then those specimens are sent to a laboratory that our office contracts with for toxicology testing, and then I usually get the results back 1 to 2 months later.
What is the purpose of having blood sent out for testing?
It varies from case to case. Sometimes toxicology provides the answer to the cause of death, such as in drug overdose cases. Other times it provides additional information about the circumstances. So for example, in a motor vehicle, it's also just, I guess to be clear, it's standard procedure in pretty much every office that cases involving trauma, a toxicology screen is performed. There's a few different ways. So one is just with handwritten notes. It's literally nothing more than me writing notes on sheets of paper to document the findings. I also document my findings photographically. So that's a big part of modern forensic pathology practice. Lots of digital photographs of pertinent positive and negative examination findings. And then probably the most formal part is for each case, I produce a typed formal written report of my examination findings. And at the completion of that case, I sign and date that document.
Dr. Weinberg, you mentioned that you take photos. Is it common for police officers or law enforcement officials to also be present when an autopsy is conducted?
It depends on the nature of the case. Actually, probably for the majority of my cases, the answer is no. But in certain kinds of cases that may involve future criminal charges, then yes, it is common for law enforcement to be in attendance, and often he or she will take photographs for themselves as well.
Dr. Weinberg, as part of an autopsy, do you determine something called cause of death?
Yes.
What does it mean to determine the cause of death?
The cause of death is the underlying disease process, injury, or intoxication that accounts for an individual's death, no matter how rapidly or how drawn out the time process involved. So examples of causes of death are medical issues such as various forms of cancer, strokes, various forms of cardiovascular disease, as well as injuries. So things like stab wounds, gunshot wounds, asphyxial injuries such as hanging or strangulation. Those are all various types of cause of death that I can put on a death certificate based on the totality of my examination and investigational findings in a case.
Dr. Weinberg, could you tell us how many autopsies have you conducted in your career?
I can't tell you an exact number because I don't keep that precise a log, but at this point in my career, about 14 years post-fellowship, it has to be just to either side of 3,000 at this point.
Dr. Weinberg, of those roughly 3,000 autopsies that you have conducted, how many involved gunshot wounds?
Hundreds.
Dr. Weinberg, have you been qualified in court as an expert in forensic pathology on previous occasions?
Yes.
Could you tell us about how many times?
Probably approaching 100 at this point, in the various jurisdictions in which I've worked and testified.
Does that include being qualified as an expert in forensic pathology in the state of New Hampshire?
Yes, multiple times at this point, yes.
Your Honor, at this time, the state moves to qualify Dr. Weinberg as an expert in forensic pathology.
He shall be so recognized.
Dr. Weinberg, did you conduct an autopsy on the body of Caitlyn Naffziger on March 1st of 2024?
Yes.
Where was this autopsy performed?
At Concord Hospital in Concord, New Hampshire.
As part of that autopsy, did you determine Ms. Naffziger's height and weight?
I did.
What were those?
If I may at this point, may I refer to my case file, which has a copy of the autopsy report?
Yes, please refer to your report for purposes of refreshing your memory.
Sure. So Ms. Naffziger was 60 inches or 5 feet tall and 114 pounds.
Dr. Weinberg, I'll ask you to just close your notes.
Sure.
Dr. Weinberg, you talked about the number of ways that you document an autopsy, including photographs and then a report. Did you do those things with regard to Ms. Naffziger's autopsy?
Yes.
Did you conduct an external examination of Ms. Naffziger's body?
Yes.
What, if anything, did you find?
Well, along with just the routine things that I document in every case, things like hair color, eye color, scars, tattoos, presence or absence thereof, things like that. The most significant thing is there were two very obvious defects to the head, which I quickly was able to recognize as gunshot wound injury.
You mentioned that there were two defects that you described as a gunshot injury. Could you describe, did you assign any sort of classification to those injuries?
Yes. During the course of the examination, ultimately I was able to determine that one of the defects represented an entry wound and the other defect represented an exit wound. Therefore, I was able to determine that there was a single gunshot wound to the head with both entry and exit wounds present.
So I'd like to ask you about that. What is an entry wound?
An entry wound is the term that a forensic pathologist will use for the defect, the injury in an individual's body.
And following that, what is an exit wound?
So same sort of thing, except now we're talking about from where the bullet exits the body. Every gunshot wound has an exit. Some gunshot wounds have.
He has
contained
elf
projectile.
ears.
That was not so in this case.
How are you able to determine the difference between an entry wound and an exit wound?
Largely, it is a product of my training and experience at this point. Simply put, they look different, and it is my training and experience that allows me to make that distinction. Most of the time, it's pretty straightforward for an experienced forensic pathologist to differentiate an entry wound from an exit wound. They look different. They have different characteristics, different features, and that's just externally. There are also internal features that can help with that distinction when necessary. Everything in this
Ernest
case
Armstrong,
did align with the ultimate way I classified,
Booger from
as one side being the entry wound and the other side being the exit.
Revenge of the Nerds.
Dr. Weinberg, you mentioned an entry wound and an exit wound, and then you classified them collectively as a gunshot.
If he had curly hair.
Yes, that's correct.
That entry wound and that exit wound were caused by the same bullet.
Yes.
Could you tell us where those wounds were?
Yes, and again, I just want to refer to my notes because I don't want to switch the laterality.
Sure.
excuse me, not my notes. I'm actually looking at the formal autopsy report. So in Miss Naffziger's case, the
That's what he
entry
looks
wound
like.
is on the left side of the head, on the temporal scalp, which basically means the portion of the head above the ear. So approximately in that general region where I'm pointing on myself, just for demonstrative purposes to the jury, but for the written record, I'm pointing slightly above my left ear. That was the entry wound in this case.
Where was the exit wound?
The exit wound was basically just on the opposite side. So on the right side, also a little bit above, the right ear.
Dr. Weinberg, were you able to determine,
That's hilarious. That's the role that made him famous.
Yes.
Why would he not want to be
The
called
bullet
that?
passed through the skull and then basically passed through the brain. The report documents the specific anatomic structures in the brain, which I can get into if necessary, but essentially the bullet passed right through Miss Naffziger's brain.
after passing through her brain, did it then exit through her skull again?
Yes, so passed through the left side of the skull, through the brain, and then through the right side of the skull, and then exited the body through the skin.
Did you recover a retained projectile from anywhere inside Miss Naffziger's body?
No, I did not in this case.
Dr. Weinberg, you told us about the path that that bullet traveled, in your expert opinion. Did you observe any internal injuries to Miss Naffziger associated with that bullet?
Well, yes, the injuries to the skull, the dura mater, which is the covering
Embarrasses him?
around the brain, and the brain were all injured by the gunshot wound in this case. They were injured by the bullet.
And could you describe just what was your diagnosis of those injuries for the record?
You mean
What were the injuries?
go specifically through the parts of the brain? Sure, I'm again going to refer to my report here, but the bullet passes through the left temporal cerebrum,
Pancake all
cerebral
over.
white matter and deep nuclei, the basal ganglia and the thalamus, the right frontotemporal cerebrum, and the right, and then out through the skull. So again, those are just specific anatomic regions of the cerebrum, which is kind of the main portion of the brain that people think about when you think of a picture of the brain.
Did you observe anything along the lines of hemorrhaging or contusion?
At least he was polite about it.
Yes, there was bleeding, which is absolutely expected, associated with any sort of traumatic injury in a living person, including a gunshot wound. There were also areas of associated bruising on the surface of the brain. These are all, just to be clear, injuries that are directly associated, and findings, I should say, associated with the gunshot wound.
Dr. Weinberg, were the injuries to Ms. Naffziger's brain from that gunshot wound fatal?
Yes,
So in other words, did those cause her death?
yes.
Dr. Weinberg, are you familiar with the term range of fire?
I am.
Could you please tell us what that is?
Sure. Range of fire is a determination that a forensic pathologist can make in a gunshot wound case that basically answers how far away was the gun at the time of discharge. So basically, we're talking about the distance between the tip of the weapon and the skin surface. And there's basically three classifications, or
Are you kidding me? He was explaining what. He wasn't even getting to any specifics of this case yet. He was just explaining what range was. Well, it's good to know that he's nice, because a lot of celebrities are not. It's like they forget that their fans are the ones that put them there. And we get excited when we see them in person, and they're just jerks about it.
Weinberg, I believe the question posed to you was, what is range of?
Sure.
I
So
wish we
think
could hear the
I was at a
questions.
point where I was explaining that as a forensic pathologist, we classify range of fire into one of three categories. And it, again, relates to the distance between the tip of the weapon and the skin surface at the time of discharge. So the first category is contact, which basically means the gun is up against the skin at the time of discharge. The second grouping is intermediate range of fire, which basically means from a few inches away up to about 3 feet. That's the intermediate range of fire, and then beyond that is a distant range of fire, or indeterminate, or, as the phrasing I use, no evidence of close range firing. So intermediate and contact are considered close range firing. That is, the tip of the weapon is less than about 3 feet from the tip of the skin.
Good Lord, people. This trial, I swear. It's interesting. It's an interesting trial. And I do want to find out what happens. I want to hear the defense's nuts. It's not necessary. Just state your objection and let the judge rule on it. You don't have to go to sidebar every time.
Dr. Weinberg, I'm going to ask you again to define those three categories of fire.
So the first category of range of fire is contact, which means the tip of the weapon is basically up against the skin surface up to maybe a couple of inches away. Intermediate range of fire means that the gun tip is a little bit further back. Usually it's defined as somewhere between 6 and 36 inches away from the skin surface. That's the intermediate range of fire. And again, in combination, contact and intermediate are
Don't feel bad,
lumped
Michelle.
as close range firing. If you don't see any of the markers of either contact or intermediate range of firing, the gunshot wound is defined as an indeterminate range of fire or distant range of fire, or the phrasing I use in my reports, no evidence of close range firing. And again, that generally means that the tip of the weapon is at least 3 feet away or more.
So Dr. Weinberg, when you determine that something is in that last category as not close range or indeterminate, you can't tell if something is 37 inches or 37 feet, can you?
That's correct.
Markers that you use to determine whether a gunshot wound falls into one of these three categories, what are those markers?
Those markers are the presence of soot around a wound, as well as imprints from the muzzle or other parts of the gun, such as a sight or a firing pin. Those are things that are generally seen in the contact range of fire. Intermediate range of fire is classically defined with the presence of something called gunpowder stippling, which are basically these tiny little pinpoint marks around a gunshot wound from gunpowder particles striking the skin. But once you get beyond about 3 feet or 36 inches, those markers generally are not going to be present, and therefore, as I said, you have no evidence of close range firing, and you can opine that the gun is 3 feet or more away from the skin surface at the time of discharge.
Dr. Weinberg, you observed on Ms. Naffziger in that third category of indeterminate or distant fire.
Yes, in my opinion, the entry gunshot wound in this case shows no evidence of close range firing.
And again, that means 3 feet or more.
Correct.
Come on, you want it? Puppy? Come on. I'll keep it cookie outside.
Dr. Weinberg, I'm showing you a series of 4 images marked for identification of states 21A through D. Could you please take a look at those?
Sure.
Dr. Weinberg, what are these?
These are during Ms. Naffziger's examination. More specifically, there are 2 photographs each of the entry and exit wounds at various magnifications or at various stages of the examination process.
Dr. Weinberg, these photos, states 21A through D, fairly and accurately represent the state of Ms. Naffziger's wounds at the time you conducted your autopsy on March 1st, 2024.
Generally, yes, there has been some alteration, and specifically what I mean is these wounds were in parts of the head where there is hair. So it's very standard in my line of work to document those wounds both as is, i.e. with the hair there, with the hair still present, and to clean and shave the skin around the entry wounds and exit wounds when there is hair present. So the clearing of the hair around the wounds that you'll see in some of these photographs, I did that as part of the examination. That's what I mean by manipulation, but otherwise, yes.
So just to be clear, Dr. Weinberg, these photos show a fair and accurate representation of Ms. Naffziger's wounds during the autopsy you conducted, and that includes both before and after you made those alterations you described by shaving or cleaning up some of those areas.
Yes, that's correct.
At this time, the state moves to strike the ID on states 21A through D.
The ID may be stricken with respect to 21A through D inclusive, and they shall be considered as full exhibits.
Dr. Weinberg, you can see up on the screen, and you have one there as well. This is States Exhibit 21A. Could you please tell the jury what they're looking at?
Yes, this is a medium magnification view showing the left side wound specifically, this picture specifically is showing the presence of the entry gunshot wound after I have cleaned it up and cleared away some of the surrounding hair.
What?
And again, Dr. Weinberg, that cleaning up, it was so that you could better
You sit in my lap?
examine this wound?
Exactly. That's
Okay, bye.
I mean, this
Keep
is just
going.
very standard forensic pathology practice throughout North America. You examine the wound as is, but you also clean it up for this exact reason. Sometimes there are features that are better seen, and I mean, I don't think I need to get into it more, but
Thank you,
that's
Doctor.
why.
And now showing you States Exhibit 21B. What is this?
This is essentially very similar to the previous photograph, except at a higher magnification. Again, it's very common to take photographs at multiple levels of magnification, just to show different features. This is a higher magnification view of the entry gunshot wound.
Now, this wound appears to be, for lack of a better term, fairly clean. There don't seem to be a lot of sharp edges. Is that a hallmark of an entry wound?
This is a very classic appearance of an entry gunshot wound. Yes, it is. It's fairly rounded in nature. It is somewhat punched out because the skin does actually get physically punched out as the bullet passes through. This is a textbook entry gunshot wound that I would use for teaching purposes.
Now showing States Exhibit 21C. What is this, Dr. Weinberg?
So this photograph is showing now the right side of Ms. Naffziger's head. There's been a little bit of cleaning at this point in the photograph, but there is, the hair obviously hasn't been removed yet. Above and in front of the right ear, there is the defect that I've previously spoken about, and this is a photograph of the exit gunshot wound in this case.
Just one more. Dr. Weinberg, what are we looking at here?
Now, so same perspective as the previous photograph, but a little bit higher magnification, and also now there has been cleaning of the wound and removing of the hair to facilitate better documentation. Here you can see the features of the exit gunshot wound, much more jagged, ragged, not that clean circular or ovoid type appearance of an entry gunshot wound. There's also a little fragment in the wound that I believe is a bony fragment from the skull having been injured. So that's what we're looking at in this photograph.
Thank you. Dr. Weinberg, observed any other injuries to Ms. Naffziger during your external or internal examinations?
No,
Any other injuries or trauma in other parts of the body?
no,
Any evidence of significant natural disease?
no,
Any significant findings from the results of Ms. Naffziger's toxicology screening?
no.
So, Dr. Weinberg, in your opinion, what was the cause of death for Ms. Naffziger?
In my opinion, Ms. Naffziger's cause of death was a gunshot wound of the head.
And it's the gunshot wound that we've been discussing and that you just described for us using pictures?
Correct.
Thank you. I have no more questions.
Okay, thank you. Take a brief recess right now.
range firing. And then we see the been associated with close range.
Correct.
But you cannot say with 100% certainty that the gun was not fired within 3 feet.
Spike.
No, I suppose not, particularly considering that there was hair overlying the entry wound, but again, I see no such markers around the entry wound in this case.
But you can't say
What,
100%
dude?
it wasn't within 3 feet.
There are very few things as a forensic pathologist that I can say with 100% certainty. It is not my opinion that the range of fire is less than 3 feet in this case.
Well, you cannot tell this jury the exact distance the gun was when it was fired, correct?
No, I certainly can't. As I said on direct, once you kind of pass that 3-foot barrier and there are no visible signs of close range firing, there's nothing I can do to distinguish whether the range of fire is, say, 40 inches or 50 inches or 80 inches, et cetera.
And you weren't there, right?
Where?
At the apartment when the shooting happened, correct?
No, of course not.
No, and so you didn't see what happened, right?
No, of course not.
And you didn't see where the gun was when it was fired, correct?
That is correct.
And you didn't see what Caitlyn was doing, correct?
Correct.
You didn't hear what she was saying, correct?
Correct.
You don't know where Dustin was when he fired it, correct?
Correct.
And you don't know if it was fired in self-defense, right?
That is not my role to assess.
Or in defense of others?
Basis? Sure.
Boy, boys fight.
And Dr. Weinberg, you do not know if it was fired in defense of others either.
I have no opinion on that matter. My role is to examine Ms. Naffziger, determine her cause and manner of death, assess injuries. It is never my role to assess that kind of thing, justifiability, self-defense, any of those questions. That is not my role as the medical examiner or as a forensic pathologist, so I have no opinion on that matter.
Your Honor, if I could just have one moment. No further questions, thank you.
Correct? Briefly, Your Honor. Dr. Weinberg, are you familiar with the term manner of death?
Yes,
What is that?
that I must do in my role. Manner of death is part of my statutory role as a medical examiner for every single case that I am involved in. So we talked about cause of death before, right? That's the injury, the medical issue, the substance toxicity that accounts for a patient's death. Manner of death is a classification relating to the circumstances around a death. Whereas cause of death is free text, I can say or write whatever I want. Manner of death is for how I classify manner of death in a case. Those options are natural, suicide, accident, homicide, or undetermined. And that is, again, it's a classification relating primarily to the circumstances of how an injury occurred for deaths that are non-natural.
Now, Dr. Weinberg, you mentioned natural, accident, homicide, suicide. Those are not legal determinations that should carry any weight with the jury, are they?
No, as far as I'm concerned, they are part of my role as a medical examiner, and they are not statements of, they're not legal determinations.
In your opinion, what was Caitlyn Naffziger's manner of death?
I classified the manner of death in this case as homicide.
Thank you. Oh, pardon me. No more questions.
Okay, recross.
Dr. Weinberg, homicide is a classification on how the injury occurred. That's what you just told us?
Generally, yes.
It's not an opinion on whether a crime occurred, though, correct?
That is most definitely correct. Yes, ma'am.
Okay, thank you.
Nothing further.
Okay. Dr. Weinberg, be excused?
Yes.
Okay, thank you.
Yes, sir. Thank you.
Over here and jump. Jump.
Good morning.
Now tell Dave I said happy birthday. Are you going to get on the desk?
Do you swear that the testimony that you're about to give is the whole truth under penalties of perjury?
I do.
Can you lower your right hand and be seated? Sergeant McLaughlin, I'm going to ask if you haven't already done so, if you can pull that microphone a little bit closer to you. Thanks
How's
so
that?
much. Sir, what is your current employment?
I'm employed, I'm a detective sergeant with New Hampshire State Police assigned to Troop C,
And how long have you been working with the New Hampshire State Police?
15
You
years.
didn't ask his
How long
name.
have you been assigned to Troop C?
15 years.
I missed his name. And I can't see through
Did you have
shadow.
law enforcement experience prior to joining the New Hampshire State Police?
I served in the military as a military policeman for 14 years.
As a sergeant with the New Hampshire State Police, what does that mean your responsibilities are?
So a detective sergeant with the state police, I have 2 detectives assigned to me, so 3 of us total.
Oh,
We're assigned to Cheshire and
almost
Sullivan
got it off
counties,
his throat.
responsible for the more serious crimes,
I don't want it.
burglaries, thefts, sex assaults, all the way up to and including homicide, assisting major crime.
When you say assisting major crime, what do you mean by major crime?
So major crime is basically what most agencies would call a homicide unit or homicide investigative unit.
And as part of your
We're
responsibilities
here.
investigation?
Get him?
Yes.
No? Okay.
Now, do you have any kinds of
Let
training
them
or
see your butt.
experience that you utilize during your job with regards to conducting investigations?
Yes.
What kinds of training do you have?
So I have basic investigative trainings. I do have training in homicide specifically. On a death investigation specifically, I do have training in interview and interrogation.
Sam, and this is Rand. Dan's favorite.
There's a lot more training and experience.
Let me ask you about that. You said that you had trainings with respect to interviews and interrogation. Are those two things interchangeable, or can you explain to us what the difference is between the two?
Sure. And this is more my definition based on my experience. But interview, I would say the person that is being interviewed would do the majority of the talking. Interrogation, on the other hand, would be, the investigator would be doing most of the talking. And interrogation is more direct questions as opposed to an interview that would be open-ended questions, and the suspect would be given the opportunity to, or the interviewee would be given the opportunity to answer those questions.
Do you conduct interviews of suspects or interrogations?
Generally, or mostly interviews. Occasionally, it does turn into an interrogation.
Did there come a time when you became involved with an investigation that was being conducted by the Major Crime Unit into a homicide that occurred on February the 29th of 2024 in Berlin, New Hampshire?
Yes.
And I guess let me back up. Troop C, what areas of New Hampshire does that cover?
So it's Cheshire County and Sullivan County, so southwest section of New Hampshire.
Where are the barracks for Troop C located?
Keene, New Hampshire,
Where in Keene?
15 Ashbrook Court, which is right off of Route 9.
How far from, let's say, the Applebee's in Keene is your troop barracks?
It's one intersection away, it's less than a mile.
What was your role in the investigation that you became a part of, the one that happened in Berlin?
So initially, I was the closest detective to a traffic stop that was ongoing. And then eventually, I was assigned to conduct an interview with Mr. Duren.
Now, can you explain how it is that you actually did become involved? You said you were the closest detective. How did you become aware of this traffic stop that was occurring?
So before that, I was aware of the death investigation for two different ways. So I received text messages for all death investigations in the state. So I was aware that there was a death investigation in Berlin in the early morning hours. I also received an Amber Alert, which added to that. When I signed on for duty that morning, it was 7:30 that morning, I signed on for duty. State Police has a computer dispatch program, and I'm able to see what's going on in the entire state. I did look to see what was going on in the Berlin case. But I was at the barracks. We monitor Keene Police Department's radio as well as Cheshire County's radio at the barracks. There was some commotion. It's in another room, so I didn't totally hear what the transmissions were. But at some point, my lieutenant popped his head into my office and said that the vehicle from the Amber Alert is at the Applebee's in Keene.
Once you heard that, what did you do?
My first reaction is, no, it's not. But after a few minutes, I decided it would probably be best, again, being the closest detective, to head over there and verify that, because I knew my phone would be ringing eventually with questions. So I drove to the Applebee's and ultimately verified that it was the correct vehicle.
And when you arrived at the Applebee's, what did you see? What was happening?
So there was a Keene police cruiser. I recognized the white Subaru. I noticed that was parked. The Keene cruiser was not far behind it. There were several other and some other people in the area. What I did was I spoke to the Keene officers, and my lieutenant was at the scene, determined that Mr. Duren was in the back of one of the cruisers, and just briefly introduced myself, expecting to have a further conversation with him later on that day.
Okay. When you say you introduced yourself, you approached Mr. Duren, and you indicated, did you introduce yourself, say who you were?
I did.
Okay. And did you ask him any questions at that point?
Basically, like, is he okay? Is there anything I can get him? Is he comfortable? And just said that he would most likely be coming to the Troop C barracks in Keene, and that we would have a lengthy conversation once he got there. What I do recall is the heat, and I felt it myself, but the heat inside the Keene cruiser was on very high, and Mr. Duren asked if I could have the Keene officer adjust that, which they did.
Now, you have looked several times towards a location in the courtroom when you say the name Mr. Duren or Duren. Do you see Mr. Duren, the person that you introduced yourself to that day here in this courtroom?
I do.
could you, by pointing him out and/or identifying him by an article of clothing that he's currently wearing, please let us know where he is?
Sure. He's seated right here, almost directly in front of me, wearing a gray suit, sorry. We'll call it a purple shirt and a paisley purple tie.
Your Honor, identifying the defendant for the record.
The record shall so reflect.
Now, when you see the defendant here today in court, does he appear to you to be does he look the same as he did when you first met him?
He's got a haircut, and his beard is a little shorter, but he does look the same.
Should I 18 for this case? Can you take a look at that and let me know if you recognize it?
I do.
What is it?
It's a photograph of Mr. Duren.
Okay, and does that photograph clearly and accurately show Mr. Duren at the time that you met him on March the 1st of 2024?
Yes.
So at this time, the state moved to express the identification. Currently publishing State's Exhibit 18 on the screen. That's how Mr. Duren appeared when you first encountered him?
Yes. Yes.
Now, you've described to us your first interaction with the defendant, how you introduced yourself to him and asked to get the heat turned down for him. Why is it that you went out to the scene and introduced yourself to him?
I would describe it as building rapport. Again, just making sure he was comfortable, and when we did get a chance to sit down and talk, I did essentially the same thing, but just make sure he's comfortable. If he needed to eat, we would get him some food. If he wanted something to drink, we would get him something to drink.
At the time that you met him at the Applebee's parking lot when he was in that cruiser, did you ask if he wanted any food?
I believe so.
Okay. Did at that time he ask for any?
For food, no.
Okay. How about for anything else?
I believe I told him that I make a good, strong cup of coffee, and we had a discussion about that, and eventually he did accept a cup of coffee.
Did you later make arrangements for him to be interviewed at Troop C?
Yes.
Can you describe for us the location inside of Troop C where that interview occurred?
So there's several entrances to Troop C, which had been renovated not long before this incident. There, to the far left of the building, there is a garage door, and just to the right of that is an entrance. Just inside that entrance to the right is an interview room.
When you say an interview room, can you describe for us sort of how large that is? What's in there?
So it's probably a 9 by 8 size room. It just has a round table with 3 chairs in one corner, and the opposite corner, it has a desk with an office chair and then a separate chair.
When you sat down to interview the defendant, Mr. Duren, who else was present, if anyone?
So Detective Horton, who works with me, eventually was present in the room as well.
This interview that you conducted of the defendant, Mr. Duren, was that audio and video recorded?
Yes.
Can you describe the manner in which that occurred?
Sure. So again, the barracks is newly renovated. We do not have a system. So in this particular case, an audio recorder, just a handheld audio recorder, was placed in the room, and then I used my state-issued cell phone to video record the interview.
Was the defendant, or did the defendant consent to this interview being recorded?
He did.
Now, with respect to the interview itself, did you have any interruptions with respect to the recording?
One interruption was so it's recording on my state cell or my cell phone. Not long into the interview, the cancellation of the Amber Alert, which is that loud, annoying sound that the cancellation of that came through the phone, which turned off the video recording.
Okay. So there may be a snag or a delay when the video is playing. Is
Yes.
that fair to say?
Yes.
Okay. Now, have you reviewed the video and audio recording of this interview that you conducted with the defendant in preparation for your testimony today?
Yes,
Did you also review a copy of the transcript of that recording?
I did.
Showing you what's marked now for identification purposes only as State's Exhibit 27. Can you just take a quick look through that? And let me know if you recognize it.
I do.
Okay, what is that?
This is a transcript of the audio recording.
Now, with respect to the transcript and the audio recording, did you review those together in order to determine if they were fully accurate?
I did.
Okay, and can you tell us if there are any errors in the transcription?
There are some.
How would you classify those errors?
So there are occasions where I'm speaking, but the text is attributed to Detective Horton. There are also some other where the audio might not be totally perfect. For example, I say the word Keene, referring to Keene Police or the city of Keene, and the transcription says Keith. There's one other that I can think of where we had a conversation about racking around in a pistol, and it says whacking instead of racking.
Okay, so like some word changes, but the video and audio is accurate to what was said. Is that
Yes.
fair to say? Okay. Now, after you were in the room and you had, and I'm gonna come grab that for you while I ask you the question, but after you were in the room and you had your cell phone set up, the recording was going, did you talk to the defendant about his Miranda rights?
I did.
And can you explain for us what Miranda rights are?
So it's his right to speak to an attorney, his right to answer questions, his right to not answer questions, and just that he could stop answering questions at any time.
Fair to say that advisement we've probably all heard on TV and Law and Order and all those other shows that just are everywhere?
Yes,
Okay. Now, when you conducted that procedure here, is it fair to say that you utilized a form?
I did.
Is that customary?
Yes. Doesn't have to be a form, but that's what I use.
Sergeant McLaughlin, I'm showing you what I've marked for identification purposes as State's Exhibit 25. Do you recognize that form?
I do.
What is it?
This is it's a State Police DSSP 105, New Hampshire State Police DSSP 105 form, which is a Miranda rights form.
Now, when you say DSSP 105, does every form within state police sort of have a number assigned to it?
It does.
And that's where the DSSP 105 is?
Yes.
Okay. But this is a form that you utilize to go over Miranda?
Yes.
In this particular form, do you recognize it in terms of being the Miranda form or waiver form that you went over with this defendant, Mr. Duren?
I do.
And is that a fair and accurate copy of the form as you completed it with Mr. Duren?
Yes.
Your Honor, at this time, the state moves to strike the identification on State's 25 and admit it into evidence as full. No objection.
The ID may be stricken with respect to Exhibit 25, and it shall be considered a full exhibit.
Can you describe the process? And if you need the form back, let me know. But can you describe the process?
So I read each line, you know, for example, line 1 is you have the right to remain silent. Typically I'll ask, in this case I asked Mr. Duren, do you understand that right? He would say yes. I put a little check mark next to that, line 1. I would read line 2 and same thing. Then I do add a little bit where I explain if you start answering questions and you decide for any reason you don't like a question or you don't want to answer a question, we can skip a question and move on, which he said he understood. And then I asked him to, so I write yes next to, do you understand these rights? And I asked him to initial that after I handed the form to him. And then I asked the second question, which is, under rights, are you willing to answer questions? He said yes. I wrote yes, asked him to initial that, and then sign the form. And then Detective Horton signed the form as a witness to Mr. Duren signing.
Now, by signing the form, is that the defendant indicating that he understood his rights as they were read to him and that he was willing to speak with you?
Yes.
Now, in addition to signing, and without telling us what, if anything, was said, did the defendant make statements to you during this interview that confirmed that he understood his rights?
Yes.
After the Miranda process, did you continue speaking with this defendant?
I did.
Can you describe the manner in which this interview was conducted in terms of interview versus interrogation and how it began?
So Mr. Duren was, I formed the opinion shortly after meeting him at, inside the King Cruiser that he was ready to talk to someone about what had happened. I would describe Mr. Duren as being very talkative that morning or afternoon. And he actually had some questions initially as well. And I had some questions that I was asked to ask about the children. So we started the conversation with basically answering Mr. Duren's questions.
Now, during the course of this interview, was the defendant again offered food and drink?
He had water and coffee before we started the interview, and I think we got him a sandwich after we finished.
If he had asked for a sandwich earlier, would you have provided that?
Yes.
Was he allowed to take breaks or use the bathroom?
Yes. Yes and no, because he had used the bathroom before, and then we kind of gave him the we asked about using the bathroom before we concluded, and Mr. Duren actually decided, let's get through the questions and then use the bathroom.
During this interview, while you were speaking with Mr. Duren, what kind of tone of voice did you use?
Pretty much what I'm using right now. Just normal, my normal self.
And what about Detective Horton? What kind of voice did he use?
Detective Horton is a little louder in general. He just speaks very loudly, but his normal voice.
Did anybody yell or scream at the defendant?
No.
Did at any point you use aggressive body language or aggressive gestures?
I don't believe so, no.
At any point was your service weapon involved?
No.
Now, who spoke more during this conversation, yourself or the defendant?
The defendant.
And who led the conversation, yourself or the defendant?
The defendant, but there, I tried very hard not to interrupt, but there were times where we had to kind of get the conversation back on track.
Now, following the interview of the defendant, was there a search warrant process that was conducted?
Yes.
Can you explain the purpose of that process?
So it's a search warrant, we call it a body warrant, so there's a collection of a number of evidence, the photo that is still on the screen, so there's a number of photographs taken to document injuries or the lack of injuries. Oops, I guess I'm not supposed to talk about that.
No, it's all right.
So we take some photos to document injuries, non-injuries, any evidence that might be on Mr. Duren at the time. There's swabs for different things. So a DNA swab would be basically a Q-tip that goes inside of his mouth to collect cells from inside of his cheek. There would be typically gunshot residue swab to his hands. There would be fingerprints, sometimes a collection of fingernails, sometimes a collection of hair, and essentially in the collection of his clothing.
Is that customary to every homicide investigation that you've worked?
Yes.
Now, in addition to collecting items from his physical person, were items of his personal property recovered?
I believe there were some items from the vehicle and some items from his person. I believe his wallet was one of those things.
Okay. Was his clothing also recovered?
His clothing was collected, yes.
And was a cellular phone recovered? You indicated that his wallet and identification cards were recovered?
Yes.
Sergeant McLaughlin, I'm showing you what is marked for identification purposes as State's Exhibit 31 in this case. Do you recognize what that is?
I do.
What is it?
It's a temporary New Hampshire driver's license.
Okay, and is that a particular person's driver's license?
It's Mr. Duren's.
Okay, and was that recovered from him during the search process?
Yes.
Your Honor, at this time, the state would seek to strike the ID and admit State's Exhibit 31 into evidence.
No objection.
The ID may be stricken with respect to Exhibit 31, and shall be considered a full exhibit.
Permission to publish.
Certainly.
Sergeant McLaughlin, I've placed State's Exhibit 31 up on the screen. You still have a copy with you. You also have a screen to look at. Does,
Bye, Carla. See you later.
All set?
Sergeant McLaughlin,
All
with
set, excuse me, all
I
set,
apologize.
Counsel? Okay, thank you.
Sergeant McLaughlin, with respect to State's Exhibit 31, which is on the screen, on all the screens, as well as in front of you, does that driver's license indicate what Mr. Duren's height and weight are?
It does.
And what were those?
His height is 5'10", and his weight is 190 pounds.
Sergeant McLaughlin, before we publish or talk about further or show or ask to admit the recording of the interview that you conducted, I have a few questions for you. During the time that the defendant was speaking with you, did he admit to you that he had shot and killed Caitlyn Naffziger?
Yes,
Did he tell you what hand he had used to fire the gun?
yes,
Which hand?
his right hand.
Did you ask the defendant whether Caitlyn was threatening to harm either him or their daughter at the time that he shot?
Yes,
What did he say?
no,
Did the defendant explain to you whether his action in shooting Caitlyn was done deliberately?
he said it was deliberate, yes.
Is it fair to say that the defendant told you that Caitlyn had crossed a line?
Yes,
Did he describe where Caitlyn was physically located when he shot her?
yes.
What did he say?
She was seated on a couch.
Did he tell you where on her body he had shot Caitlyn Naffziger?
Yes,
What did he say?
her head.
Sergeant McLaughlin, did he describe to you the path of travel that the bullet took?
Yes.
If you recall, what did he say?
In one side and out the other, essentially.
Is it fair to say that he said it went straight through?
Yes.
Did the defendant tell you where his daughter Elowyn was physically located when he fired the shot that killed Caitlyn Naffziger?
Yes.
Where was Elowyn located?
He had pulled Elowen away from Caitlyn and was holding her.
So at the time that the defendant fired the shot, he was holding Elowyn.
Yes, my understanding.
Did he describe how Elowyn reacted to the gunshot?
He described trying to shield her from seeing anything, and that Elowen kind of put her hands over her ears and said, ouch loud, or out, something loud.
Did the defendant tell you what his mindset was after he shot and killed Caitlyn?
He did.
What did he say?
He said that he knew that he was screwed, and that he performed well in stressful situations, and then he talked about
Really?
wanting to spend time with the kids before he
That was
wanted to
performing
be
well.
in or have to be a
Shooting someone was performing well.
Or did the defendant turn his
Alrighty
weapon
then.
in this instance?
He did not.
Because that makes sense.
Sergeant McLaughlin, I'm showing you what is marked for identification purposes as State's Exhibits 26A and B. Can you take a look at those items? Do
Yes,
you recognize them?
I do.
What are they?
They are video recordings of the interview with Mr. Duren.
And have you reviewed these specific discs, 26A and B?
I have,
And do they contain the full contents of the interview?
yes.
Your Honor, at this time, the state would ask to strike the ID as to these items and admit them as full.
Your Honor, may we approach?
Yes.
No, he pulled her away. So I think they both had a hold of her. Like he had the gun and pulled her away as he shot. That's the way I understood it. Why are we just staring at a driver's license? Is this another sidebar? What is going on?
As part of the state's foundation, I think it's fair to just explain to the jury that there have been some redactions, and so if they see any skips, not to, I can certainly make an instruction net to the jury that they are not to read anything into the skips. I can do that if anyone wishes, or I could just let it play. I can argue it either way. But we'll take that up when it comes. Attorney Kettles, with respect to the specific page, I do have the transcript in front of me.
Yes, Judge, I'd also like to have marked defense, or ID, defense C, I think it might be useful for this discussion.
Okay.
This is a corrected transcript that was provided by the state. It's page 1747.
Please use a microphone.
87 original numbering.
87 original numbering, so that's page 1833, line 15. It says, just to tighten up, it has the same quote I referenced earlier. Mr. Duren, could it be that I'm endangering Ellen by what I did? And I would very much say no. And just from that, even just my training, Sergeant McLaughlin, yeah, just to kind of tighten that up a little bit more, you're an expert marksman of some sort in competition, so it's fair to say you weren't endangering Ellen. So the corrected transcript provided by the state, page 1833, on the transcript itself, page 87, lines 8 through 15, makes it clear that the question that was asked of Mr. Duren by Mr. Sergeant McLaughlin was, it's fair to say you weren't endangering Ellen, to which Mr. Duren responds, yes. My review of the subtitles on the CD that the state submitted is that it says, it's fair to say you were endangering Ellen. Answer, yes. So I think the context of the statement immediately before, as well as the corrected transcript, which I'm going to hand to the monitor to mark for ID, makes it clear that the subtitles the state has are incorrect
It would be so nice if we could hear this.
An updated version that reflects the error. I think that the jury should be allowed to hear the best evidence, hear the video itself, and decide for themselves what it contains. This is why we raised the issue generally previously. We have a specific and very substantive example now, and we have the witness's testimony that the transcript contains. So to use the subtitles, it's I think improper. The best evidence is the video. We need to make sense as to core issues.
Your Honor, if I can just have one moment so that I can lay out for the court exactly the way that this motion filed in, I think, September at this point, around the 25th. With respect to redactions for the transcript, they chose to utilize the original transcript that was provided. The state followed along with what defense was choosing to do. At the motions hearing on October 7th, defense counsel ostensibly derided the fact that the state had corrected the transcript, indicating that we had tried to correct it. And they chose which transcript to utilize. They have waited until today, despite the fact that they received these videos, knew exactly what transcript was being utilized because it was subject to the court order made on their motion. They waited until today to raise this issue, despite the fact that they have had these videos with the transcript attached since Friday the 17th, which is only 10 days, actually less than 10 days after the court ruled on the redactions. They were provided with them, they have had them, they have known that today was coming. They did not raise this yesterday when no one was sitting in court. They have waited, and this is a strategic choice that they have made. At no time did the state choose which transcript to utilize. We, in fact, asked the detective to make sure it was accurate. Defense counsel complained that we corrected it. They didn't use it in their filing on September the 25th. They didn't argue it at the motions hearing on October 7th. They didn't ask the court to review it. With respect to the corrected transcript, they have had this for well over, and I'm trying to find the date, well over 6 months. This is not a surprise. There's been no effort to surprise defense. This has all been their choice. This court will advise the jury that the audio of the transcript in the interview, much as I said to the detective, the audio is the evidence. This court, I am sure, will advise this jury that the audio is the evidence and that any difference between the audio and the transcript is for them to decide. Your Honor, this is a strategic choice for the defense trying to gain an advantage. And the state objects to this entire process, but would indicate that this court has ruled on the defendant's request, has utilized the transcript the defense has requested, as has the state. And as such, the state believes this should be admitted. It should be.
Why does this fight always happen when there's a video with a transcript? Always. This always happens.
Or is this an attempt to gain a strategic advantage when the state opened up and posting the during Elwyn, and the answer yes, that
There's a jury instruction. The transcript is not evidence.
the video showed. We did not know whether the state intended to introduce the video. In all of its pleadings, it said very clearly, and in email communication with us, we're not saying we're going to introduce these statements, but if we do, then here's what we
Okay,
discuss.
supposedly,
Court's order said
I
that
think
any issues with the transcript, I believe,
what this is going with is there's a video
that the state seeks to admit the subtitles.
and a transcript.
The timing is.
And the defense wants the video out.
Nor are we saying that there was any purpose on the state's part. I'll note that it was
For some reason,
produced less than a week ago.
they can't hear her,
It's over a 2-hour interview, a 100-page transcript, and to.
but there's a transcript.
Different versions of transcripts when there's so many such discovery.
And
Your Honor, the defense was
state is saying
of this transcript, an original copy which was
what they always say about a transcript.
2024 or video itself was provided in March. The corrected transcript, I was in error. It wasn't 6 months ago. It was 11 months ago. Defense counsel has had this. They've had experience with this. It's 2 transcripts, Your Honor. We're not talking about multiple transcripts. We're talking about 2.
I mean, not that it matters that we're muted because we can barely hear it anyway, but. I guess I'm going to go ahead and fast forward to the live because they're still talking about this all the way up to the live. And we can't hear it.
Where in that process where we will be, but what we'll do is not evidence. I'm going to use the word subtitles. The subtitles are not evidence. The subtitles are intended only as an aid to help you as you listen to the recording.
That's a jury
Therefore,
instruction.
you may only consider what you hear and
Easy
understand the
peasy.
contents of the recording to be. That means if you perceive a difference between the recording and the subtitles, you must rely on the recording. Further, the court has been made aware of another potential discrepancy between the audio and the subtitles. The discrepancy will be addressed during cross-examination. Again,
Okay.
you are to consider the audio you hear to be the primary source of the
Maybe
information
it's not
you are to
transcript. Maybe it's subtitles.
understanding the defendant's objection to the process, any issue with that specific limiting instruction.
I thought I heard transcript too, though.
Continuing objection noted. Okay, Attorney Duren, any issue with that? It's 11:23. We'll suspend right now and be back at 11:30 to resume. So a regular break from now, 11:23 to 11:30. We'll resume at that time.
(11:23 to 11:30). I'm going to back it up to where the judge starts talking.
What we'll do, transcript many
Wait.
times, but I wasn't sure how long it was.
Well, I hate this big old red dot.
I think it's 2 hours, 6 minutes and some change.
I wasn't sure, I wasn't aware of how long it was. I know it was lengthy, and I have reviewed the transcript many times, but I wasn't sure how long it was. Counsel's preference relative to the,
I think a preference to start now, go for an hour, take a break. I think that will ensure we have full attention. It can be more difficult to pay full attention to our video.
okay, given the current time, I'm inclined to stop at 12:30, Attorney Duren, but I don't know where in that process, where we will be. But what we'll do is, based upon the defendant's position as just articulated by Attorney Kettles, what we'll do is we'll start the video at some point between 12:10 and 12:30. At some point in that range, Attorney Duren, whatever works for you from your presentation, we'll stop there, and I will have a full hour for lunch. Okay, so once again, I'm going to, my ruling is that the state can play the video with the subtitles. I'm going to be providing a limiting instruction as follows. Excuse me. Members of the jury, Exhibit 26B, a recording will now be played. A transcript of that recording will be visible on the screen below the video recording. The transcript is not evidence. I'm gonna use the word subtitles. The subtitles are not evidence. The subtitles are intended only as an aid to help you as you listen to the recording. Therefore, you may only consider what you hear and understand the contents of the recording to be. That means if you perceive a difference between the recording and the subtitles, you must rely on the recording. Further, the court has been made aware of another potential discrepancy between the audio and the subtitles. The discrepancy will be addressed during cross-examination. Again, you are to consider the audio you hear to be the primary source of the information you are to consider. Understanding the defendant's objection to the process, any issue with that specific limiting instruction? Continuing objection noted. Okay, Attorney Duren, any issue with that?
I think he was calling the
So
subtitle
11:23,
the transcript
11:23, we'll suspend right now and be back at 11:30.
and then changed it.
So a regular break from now, 11:30, 11:30, 11:23 to 11:30. We'll resume at that time.
So I think what's going on is that there is a video that's going to accompany the next witness that has subtitles. And as you know, always with subtitles, they don't always match the video. So the defense doesn't want it played because of the discrepancy. The state still wants it in. So now there has to be a jury instruction that the subtitles are not the evidence, just as if they were given a transcript along with the video. So the subtitles are not the evidence, the video is the evidence. So if there's a discrepancy between the subtitles and what they hear on the video, they have to go by what the video says. Yeah, I know, it's semantics. It's semantics. Because that transcript jury instruction is a standard jury instruction that they give a jury every time they have a transcript for something. That's a common thing that happens in trials. We see it all the time. But because it's subtitles, it's different? No, it's not. It's the same thing. So I guess now the defense gets to question the witness as to why the subtitles are different than the video. How would they know? I mean, I guess if it's an interrogation, I don't even know what the video is. If it's like his interrogation video and the witness is one of the cops and they say, that's not what he said something else, then yeah. But if it's like surveillance video or something, I guess we'll just wait to judge when we see it. If we see it. But I'm still waiting for the defense. Well, they're going to rest their case today. State's going to rest their case today. So I want him to take the stand. You guys think he'll take the stand? I want to hear it from his mouth. Why he thought he was doing this in defense of others. I don't think he's saying it was self-defense for him. I think he's saying it was in defense of others. Because he said that his wife was kidnapping his kids. Or his girlfriend, whatever he called her. Baby mama, whatever. But you can't kidnap your own kids. Unless he had like a court order that said he was the dad, right? Because they weren't married. So technically, he was the kidnapper because he's not legally the dad. Why did everything just go white? It either just goes white for no reason or black for no reason. Probably. Just like the rose petal dude. Marty, did the guy that killed the woman because she was making certain kinds of videos with her daughter and her boyfriend? You can't find anything on her, Nichelle? That's weird. Oh, the rose petal trial. Did you watch it with us? The guy killed his friend's ex because she was making with her daughter and her boyfriend. Crazy trial. But yeah, he took to save the little girl. He was at school at the time in no danger whatsoever. Oh, wow. Jerry was last seen in San Pablo, California on June 6, 1979.
Exhibit identification.
Aw, she's adorable.
Thank you.
Oh, there's even a picture of her, like, aged up. Well, she's in the Doe Network and everything. How old am I, Marty?
Thank you. Please be seated. Sergeant, you're still under oath? You're still under oath?
Thank you, Your Honor.
Okay. Attorney Duren, my understanding is that you were submitting the exhibit for admission?
Yes, Your Honor. At this time, the state would move to strike the ID off of State's Exhibits 26A and 26B and move to admit them as full.
And
And Judge, in addition to the prior discussion, I would just note that no objection to the non-title version being admitted as full.
so the ID may be stricken with respect to 26B from defense perspective?
Yes, Your Honor.
Okay, the ID shall be stricken with respect to Exhibit 26B, and I'm denying the state's request with respect to 26A as it relates to the inclusion as a full exhibit, but not for purposes of presentation.
Now, Sergeant McLaughlin, before we continue with respect to this, I just wanted to ask you a couple more questions. Do you recall at what point you conducted a review of the transcript that you saw, State's Exhibit 27? At what point you conducted that review in order to determine if there were any typographical or other errors inside of the transcript?
I'd say it was over a year ago,
Okay.
close to a year ago.
And have you been able to look at your corrected version next to the version that was the original that you reviewed?
Briefly.
For lack of a better way to ask that question. I'm going to ask you to take a look at State's Exhibit 32, which I have marked for identification purposes. Now, these are bait stamped pages. I'm going to approach and show you what I've marked for identification purposes as State's Exhibit 32 for the record. Bait stamp pages 1747 through 1919. Can you take a look at State's Exhibit 32 and tell me if you can do it?
I recognize it as a transcribed portion of the audio recording.
Okay. And if you look at that exhibit in conjunction with State's 27, which you also have, can you take a look to see if there have been any corrections made? And maybe in order to assist you, I'll direct you to a specific page. If you can look at page 89 of both of those exhibits, and that would be the 89 at the top of the page, not the bait stamp number. I believe with respect to State's 27, that would be bait stamp number 478, and I cannot tell you with respect to the other at this time.
89 on both copies.
Yes. So beginning at the bottom of page 89 and moving into page 90, I apologize.
Okay.
Are there any corrections that you made on that page? answer is no, that's fine.
It looks like it's the same. At the bottom?
Okay, so no corrections?
Not that I'm seeing.
Perfect. Can you move to page 87 in both documents?
87, backwards?
Correct.
Okay. Okay.
I'd like to draw your attention what should be the middle of the page. Do you see any corrections to page 87 that
Why? 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 Why are we going all over typos in a transcript?
In the middle of the page, I'm not seeing anything.
Okay. May I approach?
Certainly.
Going to point you to lines 12 to 17, if you can read through those sections, and let me know if there is a difference in, between those lines, between lines 12 and 17 on page 87.
Okay, yes, I see it now.
Okay, is there a place in the original transcript, not the one that you reviewed, where the person who listened to the audio heard, what did the person on the audio hear? Go ahead and tell us.
So there's, in one copy, it says the word were, and in the other copy is the word weren't.
Okay, and is the word were correct or the word weren't?
The correction I made was weren't.
Okay, and you based that correction on listening to the audio, is that correct?
Yes,
Okay, you had been present, you heard the audio, and you looked at the transcript and saw that it was an error.
yes,
Okay, so the audio with respect
No.
to the statement that you took of the defendant, in that audio, does the defendant tell you that he knew that he was endangering his daughter at the time? Did you ask him that?
I did,
You asked him if he was endangering his daughter when he fired the shot, correct?
correct.
What was the defendant's response?
So I asked him if he, so I'm not reading this, correct?
Tell us from your recollection.
Okay. So I asked him if Elwin was in danger when he fired the gun.
And what was his answer?
So I asked, I actually, I have to read this, I think, because I asked, it's fair to say you weren't endangering Elwin, and he said yes.
Okay.
So it's fair to say that he wasn't endangering Elwin.
Okay, but the transcript that is the original transcript to this audio, the word weren't came across as the word were, is that correct?
Correct.
Okay, but in all cases, just like you did, anyone listening to the audio should take the audio as the evidence, is that fair to say?
Yes.
I don't hear a clicking sound.
Your Honor, at this time, the state would, pursuant with all the orders of this court and the court's indication, publish State's Exhibit 26A for the jury.
Do you hear it now?
Okay. Members of the jury, Exhibit 26A, a recording will now be played. Subtitles for that recording will be visible on the screen below the video recording. The subtitles are not evidence. The subtitles are intended only as an aid to help you as you listen to the recording. Therefore, you may only consider what you hear and understand the contents of the recording to be. That means if you perceive a difference between the recording and the subtitles, you must rely on the recording. The court has been made aware of a potential discrepancy between the audio and the subtitles. The discrepancy may be addressed during cross-examination. Again, you are to consider to be the primary source of the information you are to consider. Thank you.
Thought maybe it was my ring against this, but if you're still hearing it, because I stopped for a while. Although it's not loud, I don't think you could. I don't know, without the mic, I don't know what you can hear and what you can't anymore.
Your Honor, at this time, publishing State's Exhibit 26A. And one more question, Sergeant McLaughlin, before I go. I think we already asked you this, but because it's been a little bit, how long was the interview that you conducted with the defendant?
That's over 2 hours.
Okay, approximately 2 hours and 6 minutes.
And based upon that answer, I'm going to tell the jury we will be taking a break for lunch during the viewing of the video.
Thank you, Your Honor.
Certainly.
Short answer, yes. Long answer, let me do this part first. And then I'll tell you who. So we'll start kind of like your priority, because we're going to try to answer your best, your questions best, because I know it's going to be gazillion things.
I don't hear it.
And then we'll kind of talk about here. Before we do anything else, water, coffee, good? So I'm going to read you
What is the cameraman doing? Oh, for crying out loud. Why does a approach every 5 minutes?
Okay, members of the jury, it's my understanding that the audio is at the maximum level. Can you hear? Can the jury members hear? Let the record reflect that they're nodding yes. And the audio will stay up as much as it can during the entire time.
Anything you say can be used against you in court. You understand that? You have a right to talk to a lawyer for advice before any questioning, and to have one with you during questioning. You understand that? Yes. If you cannot afford a lawyer, one will be appointed for you. You understand that? Yes. And if you decide to answer questions now without a lawyer present, you still have the right to stop answering questions. You understand that?
Hey, Carla.
So the
I hear it now.
girls are at Cheshire Medical, which is down here in Keene, affiliated with Dr.
Sounds like a clock.
And my understanding is that Caitlyn's aunt, Brenda, is assuming DC, so East West, you're from Minnesota, right? Yes. In New Hampshire, East West is like Department of Children, Youth, and Families. So they're kind of like CVS, whatever it is in Minnesota, Child Protection Services. So that at this point, they kind of like review everything. They actually have some questions that I want to ask you too, just about this health and department and stuff like that. They kind of step in because of what's going on. And then they always try to get the girls to some kind of, whether it's family in Minnesota or family here in New Hampshire. Brenda is probably the closest student. So she's kind of in contact or in contact with us. So that's kind of like plan A at this point, assuming DCOF is okay with everything. It sounds like Brenda will be kind of agree with since she is that a good option for now.
For now. I guess how this goes, can I just ask questions whenever?
Yeah. Well, I'm very easy, as you probably figured out.
Well, I was gonna ask, there, I guess did someone contact the police?
Third. Well, so yeah. So when like an animal or statewide, I would imagine it will be under 4 a.m. And that's something we started here.
No, I meant,
Right?
no, I meant, how did police know anything even happened?
Yeah, they don't know. The Berlin police went to the house apartment, and that's from there. I don't know how they got home. I don't know their neighbors.
But
Yeah, I don't know.
I guess I'll say, for just family, kind of one of the things was I want to make sure that my mom was aware. And that was my preference. So I just want to make sure that my mom knew that the kids were here.
Where's your mom?
She's in this.
It's 2024. I couldn't tell you phone number off the top of my head. Do you know where it's from?
This is my phone.
Where is your phone? Kinky. Probably.
At the scene.
What's your mom's name? D-E-O-R-A-H.
D-E-B-R-A.
Same last name. So, do the kids have a primary care in New Hampshire? Yeah.
No, I literally, I'm supposed to have a phone call today.
What hospital? Or where?
Because, we'll probably get into this, because I'm assuming you don't want like an entire walkthrough. We lived in Nevada before here.
Minnesota, Nevada. No, New Hampshire.
So Minnesota, Minnesota was never really big. I've been in Nevada, I mean, it's like a big drag, I should say. We've been in Nevada for the past, well, she was in Nevada, and all of us were in Nevada. deciding that one day, like, also this was surrender here in New Hampshire. And then, yeah, then I had thought, oh, I'll try to eat breakfast. And that was actually really hard.
So,
Somehow, and I didn't notice when I tried to eat, I was like, I saw the Chili's, and then I saw the police department right
wish I could hear it.
she was,
Um, I don't think it's a metronome. I think it's a clock. Um, the metronome that the guy used in his closing argument, I don't remember which trial it was. That was on purpose. That was part of his closing, and it was the most ridiculous thing I ever saw in my life. Um, no, it wasn't Broderick. Broderick, that was a crazy woman that, right? Wasn't Broderick the nutso woman that stabbed the toddler? I didn't watch that one. I mean, I didn't stream that one. Um, it was, it was Isabel, wasn't it? And he did it. I thought it was to pace himself, but then he ended up using it as some sort of analogy in his closing, and it was stupid. I don't remember. But I think this is a clock because it's faint.
very aggressive. She's a pauper, and she has all the rights. And so it was getting to a point to where she was deciding to keep the kids away from me. And there's a bunch of different stuff. I'm not going to talk to you about where and some where. But they're kind of studying, like the UCC, JE, sit down with her and her dad.
Well, I wanted to hear his side of the story, but I can't hear it. Can't hear it.
Just continue the motivation that she agreed that this was, I don't know the exact date, probably, which is probably about 13 years, but all the texts and phone calls and stuff like that, I'm sure that we would go through this, it's kind of hard for her, but rather than us, I think we specifically
Your Honor, noting the time is 12:15 and Ms. Mike Jacob is.
With the playing of the video after the lunch break, we'll suspend here for the lunch break. Members of the jury, once again, please do not discuss the case amongst yourselves or with anyone else. Please conduct no research or transmit any information about the case to anyone else. And again, if you do run into anybody at any place in Lancaster during the lunch break, please don't take offense if they don't speak to you at all. We will resume at 1:15. Thank you.
All right.
Okay, I guess there's nothing else. Okay, guys, 1:15. Have a great lunch. I will see you then.